the sound of my snow machine roaring to life on that frigid January morning in Eagle River. Alaska was about to start the biggest legal battle of my life, and I had absolutely no idea what I was getting myself into. My name is Brandon Edwards, and I had lived in the Timber Ridge development for 3 years. The property sat about 15 miles north of Anchorage, nestled in the foothills with direct access to some of the best snow machining trails in the state. When I bought my house back in 2023, one of the main selling points was the trail system that ran through the back of the development. I had specifically verified with my real estate agent, my lawyer, and even the previous owner that these trails were deeded easements, legally accessible to property owners like myself who had purchased lots bordering them. I had spent thousands of dollars on my Polaris snow machine, and every winter weekend, I would fire it up and spend hours riding through the wilderness. It was my escape from my job as a civil engineer, my way of clearing my head and enjoying the Alaskan landscape that I had moved here for in the first place. Everything changed on a Tuesday morning in early January 2026, when I found a certified letter in my mailbox. The return address showed it was from the Timber Ridge Homeowners Association, which immediately made my stomach sink. I had dealt with the HOA before over minor things like needing approval for my fence color, but this felt different. The weight of the envelope, the formal nature of it, told me something big was coming. I opened it standing right there by my mailbox, the cold air biting at my fingers as I unfolded the official letterhead. The letter was signed by Karen Abbott, the HOA president, a woman in her late 40s who had made it her personal mission to control every aspect of life in our development. She had blonde hair that was always styled in that specific way that screamed suburban authority, and she drove a white Lexus SUV with vanity plates that read Hopres. The letter stated that, effective immediately, all snow machines, ATVs, dirt bikes, and similar recreational vehicles were banned from operating within the Timber Ridge development boundaries. The reasoning they provided was noise complaints, environmental concerns, and safety issues. Violators would face fines starting at $500 per incident, escalating to potential legal action and liens against properties. I read the letter 3 times, my anger building with each pass. The trails they were talking about were not HOA property. When I purchased my home, I had received a separate deed for a trail easement that explicitly granted me and other qualifying property owners perpetual access to use these paths for recreational purposes. The HOA had no legal authority over those easements, or at least that is what I believed based on my property documents. I immediately went inside and pulled out my closing documents from the filing cabinet in my home office. I spread everything across my desk and found exactly what I was looking for. There it was, clear as day. A recorded easement deed showing that lots 47 through 89, which included my property at lot 62, had deeded access to the trail system marked as easement parcel E7. This easement had been established in 1998 when the development was first platted, long before the HOA even existed in its current form. I grabbed my phone and called my neighbor, Derek, who lived 2 houses down and also used the trails regularly. He picked up on the second ring. "Did you get the letter?" I asked without preamble. "Yeah, I'm looking at it right now," Derek said, and I could hear the frustration in his voice. "This is complete garbage. Karen and her cronies can't just ban us from using our own property rights." That's what I thought. "I'm looking at my easement deed right now. This is recorded with the state. The HOA can't override a property deed." "So what are we going to do?" Derek asked. "I'm going riding this weekend like I always do," I said firmly. They want to fine me, let them try. I'll see them in court if it comes to that. Derek was quiet for a moment. Man, I don't know. Karen is ruthless. You know she got the Hendersons fined $3,000 last year over their shed being 2 inches over the setback line. This is different. This isn't about HOA covenants or architectural guidelines. This is about property rights that were deeded before most of us even moved here. They're completely overstepping. All right, Derek said slowly. Keep me posted on what happens. I might join you if you don't get arrested or something. I laughed, though it was not particularly funny. It won't come to that. This is a civil matter and I'm on solid legal ground. I spent the rest of that week doing research. I pulled up the HOA covenants and read through all 73 pages of them. Nowhere in the covenants was there any mention of the trail easements or any authority granted to the HOA to regulate their use. The covenants covered things like exterior paint colors, fence heights, parking regulations, and architectural modifications, but nothing about easements or trails. I also researched Alaska property law and found multiple cases supporting my position. Easements, once granted and recorded, run with the land and cannot be eliminated or restricted by subsequent HOA rules unless the easement itself grants that authority. My easement contained no such language. By Friday evening, I was confident in my legal position. I spent Saturday morning getting my snow machine ready, checking the track, adding fresh fuel, and making sure everything was in perfect working order. The weather forecast showed clear skies and temperatures in the low 20s, perfect conditions for riding. Sunday morning arrived with brilliant sunshine sparkling off the snow-covered landscape. I had my gear on by 8 in the morning, thermal layers, insulated bibs, heavy winter coat, helmet, and gloves. I loaded my GPS unit with the trail maps and made sure my phone was fully charged and tucked in an interior pocket where it would not freeze. I fired up the Polaris, and the engine settled into a steady rumble. I let it warm up for a few minutes in my driveway, checking the gauges and making sure everything looked good. Then, I eased the throttle forward and headed toward the trail access point at the back of the development. The trail entrance was marked by 2 wooden posts with a small sign that read, "Private easement authorized users only." I had every right to be there, so I guided my snow machine between the posts and onto the packed snow trail beyond. The first half-mile was pure enjoyment. The trail wound through dense spruce forest, the branches heavy with snow. The morning sun filtered through the trees, creating shadows and light patterns across the white landscape. My snow machine handled beautifully, and for those first few minutes, I forgot all about the HOA and their ridiculous letter. Then I rounded a bend and saw Karen Abbott standing directly in the middle of the trail. She was bundled up in an expensive-looking white parka with fur trim around the hood, her hands on her hips in a posture of absolute authority. Behind her stood 2 other HOA board members, Linda Martinez and Craig Foster. Linda was holding what appeared to be a video camera pointed directly at me. I slowed the snow machine and came to a stop about 20 feet from them, leaving the engine running. I flipped up my helmet visor. "You need to move," I called out over the engine noise. "Brandon Edwards," Karen shouted back, her voice sharp and carrying easily in the cold air. "You are in direct violation of the HOA directive issued on January 7th. You need to turn that machine around immediately and return to your property." "I'm on a deeded easement that I own access rights to," I replied, keeping my voice level. "The HOA has no authority here." "Now please move out of the trail." "This trail runs through HOA common areas," Karen insisted. "We have every right to regulate what happens on HOA property." Show me the deed that says this easement is HOA property, I countered. Because I have the recorded easement right here that says otherwise. I patted the chest pocket of my coat where I had folded copies of my property documents, knowing this confrontation was likely. We don't need to show you anything, Craig Foster interjected. He was a stocky man in his 50s who worked as a middle manager at some company in Anchorage. The HOA board has spoken. If you proceed, you will be fined $500 and we have video evidence of your violation. Fine me then, I said. I'll see you in court. Now move or I'm going around you. Karen's face flushed red, visible even in the cold. You cannot speak to us like that. We are your duly elected HOA board. You're 3 people standing in the middle of a trail where you have no legal authority, I corrected. Last chance to move. They did not move. Karen crossed her arms and planted her feet wider, as if she could physically stop a 400-pound snow machine through sheer will. I was not going to run them over, obviously, but the trail was about 12 feet wide at this point, and there was plenty of room to go around them. I eased the throttle forward and guided the snow machine to the left side of the trail, giving them a wide berth. This is being recorded. Linda shouted, waving the camera. You're going to regret this, I did not respond. I simply continued past them and accelerated once I was clear, heading deeper into the trail system. In my mirrors, I could see Karen frantically pulling out her phone, probably to call someone. I did not care. I had done nothing wrong. I spent the next 3 hours riding the trails, exploring paths I had not visited since last winter. The terrain was spectacular, ranging from flat straightaways through meadows to technical sections winding through forest. I saw a moose at one point, a massive bull that watched me pass from a distance of about 50 yards. I saw rabbit tracks and even what looked like wolf prints crossing the trail in one section. It was exactly the kind of day I had been looking forward to, and I refused to let the HOA confrontation ruin it. By the time I headed back to my house around noon, I felt refreshed and confident in my position. That confidence lasted until Monday morning when I found another certified letter in my mailbox, this time with a notice of fine enclosed. The HOA was charging me $500 for violation of their snow machine ban, with detailed descriptions of my transgression, including timestamps and references to video evidence. The letter gave me 15 days to pay the fine, after which it would increase to $750, and if still unpaid after 30 days, the HOA would place a lien on my property. I photographed the letter and immediately called a lawyer. I had a friend from college, Marcus, who practiced real estate law in Anchorage. I explained the situation and emailed him copies of all my documents, including the easement deed, the HOA covenants, and the fine notice. Marcus called me back within 2 hours. Brandon, you're absolutely right. The HOA has no authority over that easement. The easement is a property right that was granted and recorded. Unless the easement document itself gives the HOA regulatory power, which it doesn't, they can't restrict your use. So what do I do about the fine? Don't pay it, Marcus said firmly. If you pay it, you're essentially admitting they have authority. Instead, I'll draft a response letter citing the easement and explaining why the HOA lacks jurisdiction. If they want to push this, they'll have to take you to court, and they'll lose. How much is this going to cost me? I asked, already dreading the answer. I'll do the response letter for $500, Marcus said. If this goes to actual litigation, we're looking at several thousand minimum, but honestly, I don't think it will get that far. Once they realize they're on weak legal ground, they'll probably back off. I agreed, and Marcus sent me a retainer agreement that same day. By Wednesday, he had drafted a comprehensive response letter explaining the legal basis for my easement rights and demanding that the HOA withdraw the fine. The letter was professional but firm, citing multiple Alaska court cases and property law statutes. I thought that would be the end of it. I was wrong. The following Sunday, I went riding again. This time, Karen and her board members were not physically blocking the trail, but they were stationed at the trail entrance with cameras and notepads, documenting everything. I waved at them as I passed, which probably did not help the situation, but I was frustrated with their harassment. I got another fine notice the next day, $500 for a second violation. The letter warned that a third violation would result in a $1,000 fine and immediate legal action. Marcus sent another response letter, this time more strongly worded, warning the HOA that their continued harassment could result in a countersuit for abuse of process and interference with property rights. Things escalated from there. The HOA called an emergency meeting, which I attended. The meeting was held at the community clubhouse on a Thursday evening. About 40 homeowners showed up, which was a pretty good turnout for our development of 200 homes. Karen ran the meeting with an iron fist, using a gavel that she seemed to enjoy banging way too much. The agenda included several mundane items about landscaping budgets and parking enforcement, but the main event was clearly listed as discussion and vote on recreational vehicle enforcement. When that item came up, Karen launched into a 15-minute presentation about the dangers of snow machines, the noise complaints she claimed to have received, and the environmental damage she insisted was occurring. She had prepared a slideshow with photos of snow machine tracks in the snow, noise pollution charts she had printed from the internet, and even pictures of snow machine accidents from news stories that had nothing to do with our trails. When she finally finished, I raised my hand. Karen looked like she wanted to ignore me, but there were too many people watching. "Yes, Brandon," she said with forced politeness. I stood up. "Everything you just presented is irrelevant. The trails you're trying to ban us from using are deeded easements. I have, and several other property owners have, legal recorded access rights to those trails. The HOA has no authority to ban us from using our own property rights." A murmur went through the crowd. Several people nodded in agreement. "The HOA has a responsibility to all residents," Karen countered. "Your use of these machines affects the quality of life for everyone in the development. Then you should have thought about that before you sold homes with trail easements attached," I replied. "You can't sell someone a property right and then take it away because you decide you don't like it anymore." Craig Foster stood up. "We've consulted with our HOA attorney, and we've been assured that we have the authority to regulate activities within the development boundaries." "Then your attorney is wrong, or you're misunderstanding what they told you," I said. "I've consulted with a real estate attorney who specializes in property rights, and he's confirmed that your ban is illegal." This led to a heated back and forth. Other homeowners joined in, some supporting me and others supporting the HOA board. I learned that there were at least 6 other property owners with trail easements who were also being targeted by the ban. One of them, a guy named Robert who lived on the other side of the development, stood up and said he had also consulted an attorney and received the same advice I had. The meeting devolved into chaos, with people shouting over each other. Karen banged her gavel repeatedly, trying to regain control. Eventually, she called for a vote on whether to uphold the snow machine ban. Out of the 40 homeowners present, 23 voted to uphold it, 12 voted against it, and 5 abstained. Karen looked triumphant. "The homeowners have spoken. The ban remains in effect." "That vote is meaningless," I said, still standing. You can't vote away someone's property rights. This isn't a democracy when it comes to deeded easements. Those are legal contracts recorded with the state. This meeting is adjourned, Karen announced, banging her gavel one final time. I left the meeting angry but more determined than ever. I talked with Robert and the 4 other easement holders who had shown up. We agreed to form a united front. One of them, a woman named Jennifer who was an accountant, suggested we pool resources and hire Marcus together to represent all of us if it came to litigation. The situation got worse before it got better. The HOA started sending fine notices weekly, claiming each day I had my snow machine visible in my driveway was a violation of their storage restrictions. They claimed vehicles used in violation of HOA rules could not be stored in plain sight. I took photos every day of other people's boats, trailers, and recreational vehicles sitting in driveways throughout the development, documenting the selective enforcement. Marcus said this would be useful if we ended up in court. In February, things took an unexpected turn. I came home from work one Tuesday to find a boot lock device attached to my snow machine. It was one of those bright yellow wheel locks that parking enforcement uses, clamped around the track of my Polaris. I was stunned. I immediately called the police non-emergency line and reported what I believed to be vandalism or theft of my property. 2 officers showed up within 30 minutes. Officer Martinez was a veteran cop in his 40s who took my statement carefully. I explained the ongoing dispute with the HOA and showed him the boot lock on my snow machine. "You know who put this on your vehicle?" he asked. "I assume it was the HOA, but I don't have proof. I was at work all day." Officer Martinez walked around my snow machine, taking photos. "This is your private property in your driveway, correct?" "Yes, sir." "Then someone has tampered with your property without permission." He turned to his partner, a younger officer named Stevens. "Let's go talk to the HOA." I gave them Karen Abbott's address, which was only 4 streets over. The officers told me to wait at my house. About 45 minutes later, they returned. Officer Martinez had an interesting expression on his face. Well, that was enlightening. Mrs. Abbott admitted that she authorized a private security company to place the boot lock on your snow machine. She claims the HOA has the authority to do this under their enforcement powers. "Can she do that legally?" I asked, though I already suspected the answer. "No, she cannot," Officer Martinez said firmly. The HOA's authority extends to fines and liens in accordance with their covenants and state law. They cannot physically restrain or impound your personal property without a court order. What they did is technically vandalism and possibly theft or conversion of property. My eyes widened. "So what happens now?" Mrs. Abbott has agreed to have the boot lock removed immediately. A representative from the security company is on their way now. However, you would be within your rights to press charges. I thought about it. Part of me wanted to see Karen face consequences for her overreach, but I also knew that pressing criminal charges would make this situation even more hostile. "Let me think about it," I said. "Can I decide later?" "You have up to a year to file charges for this type of misdemeanor," Officer Martinez confirmed, "but I'd recommend documenting everything. Take photos once the boot is removed. Keep records of all interactions. If this escalates further, you'll want that documentation." 20 minutes later, a sheepish-looking security guard showed up with a key and removed the boot lock from my snow machine. He would not make eye contact with me and left immediately after finishing. Officer Martinez gave me a case number and his card. "If they try anything like this again, call us immediately. And sir, for what it's worth, I've dealt with HOA disputes before. You might want to consider getting a restraining order if this harassment continues." After the officers left, I called Marcus and told him what had happened. He was almost gleeful. "Brandon, this is huge. They just committed actual crimes. We're not talking about a civil dispute anymore. They physically tampered with your property. This completely undermines their position and shows a pattern of harassment and illegal behavior. What should I do?" "First, I'm going to draft a demand letter that is much stronger than the previous ones. This letter is going to threaten not just a lawsuit for interference with property rights, but also civil claims for harassment, conversion, and abuse of process. Second, I think we should seriously consider filing a lawsuit rather than waiting for them to sue you. We go on the offensive. How much is that going to cost?" Marcus was quiet for a moment. "With the 6 of you pooling resources, probably 3,000 to 4,000 each to get through initial filings and discovery. But here's the thing: if we win, which I'm very confident we will, we can ask the court to award attorney fees. The HOA would have to pay your legal costs." I discussed it with the other easement holders. We met at Robert's house that Saturday, all 6 of us sitting around his kitchen table. Everyone was dealing with similar harassment from the HOA, though I seemed to be getting the worst of it because I had openly defied them from the beginning. Jennifer ran the numbers. If we each put in 4,000, that gives Marcus 24,000 to work with. That should be enough for him to file a declaratory judgment action and get through the initial stages. A declaratory judgment, Marcus had explained, was a lawsuit asking the court to declare what the legal rights actually were. We would be asking a judge to officially rule that our easements were valid and that the HOA had no authority to restrict their use. We all agreed. By Monday, Marcus had retainer agreements signed by all 6 of us and a check for $24,000. He filed the lawsuit in Anchorage Superior Court on Wednesday, February 19, 2026. The lawsuit named the Timber Ridge Homeowners Association as the defendant and laid out our case clearly. We had valid, recorded easements granting us trail access. The HOA had no authority to restrict those easements, and the HOA's actions constituted harassment and interference with property rights. We asked the court for a declaratory judgment, an injunction preventing the HOA from further interference, and attorney fees. The news spread through the development like wildfire. I started getting phone calls from other homeowners, some supporting me and others angry that I was suing the HOA. One neighbor, an older woman named Patricia who lived across the street, brought me a plate of cookies and told me she thought the board had been overstepping their authority for years, and she was glad someone was finally standing up to them. Another neighbor, Frank, who was friends with Craig Foster, stopped me while I was getting my mail and told me I was going to destroy the development and tank everyone's property values with my lawsuit. I tried to explain that I was simply defending my property rights, but he walked away before I could finish. The HOA had 30 days to respond to the lawsuit. During that time, I continued to ride my snow machine every weekend. I figured I might as well, since we were already in court. Each time, Karen or another board member was there photographing and documenting, adding to their pile of alleged violations. The HOA's response when it came was aggressive. They had hired a law firm out of Anchorage called Peterson and Gray, and their attorney, a woman named Sandra Peterson, filed a motion to dismiss our lawsuit. Her argument was that we had not exhausted our internal HOA remedies before going to court, and that the HOA covenants required arbitration before litigation. Marcus filed a response brief, explaining that internal remedies and arbitration requirements did not apply to disputes over property rights that existed independently of the HOA, and that the easements predated the current HOA covenants anyway. The judge scheduled a hearing on the motion to dismiss for late March. In the meantime, the HOA continued to rack up fines against all 6 of us. By early March, they claimed I owed over $8,000 in accumulated fines. I had a file folder stuffed with violation notices and fine letters. The hearing was on March 24th. All 6 of us showed up, along with Marcus. The courtroom was one of the smaller ones in the Anchorage courthouse, with maybe 30 seats for spectators. About half of them were filled with homeowners from our development, split between supporters and HOA board loyalists. Judge Patricia Hensley presided. She was in her early 60s with short gray hair and a no-nonsense demeanor. She had both attorneys approach the bench before the hearing started and said something I could not hear, but both lawyers nodded. The hearing lasted about 90 minutes. Sandra Peterson argued that we had to go through HOA channels first, that the court should not interfere in internal HOA matters, and that the easements were subject to reasonable HOA regulation. Marcus countered with a clear explanation of property law, pointing out that easements are property rights recorded with the state and cannot be restricted by HOA rules unless the easement itself allows for it. He presented the easement deeds, showing that they contained no language granting the HOA any regulatory authority. He also pointed out that the HOA covenants themselves made no mention of the easements, proving they were separate and independent. Judge Hensley asked sharp questions of both attorneys. She seemed particularly interested in the exact language of the easements and whether the HOA covenants had any provisions about trails or recreational vehicles. At the end of the hearing, Judge Hensley did not rule from the bench. She said she would issue a written decision within 2 weeks. Those 2 weeks were agonizing. I tried not to obsess over it, but it was hard. My entire position was riding on this motion. If the judge dismissed our lawsuit, we would be stuck in HOA arbitration, which would cost even more money and drag things out for months. The decision came down on April 7th. Marcus called me at work, and I could hear the smile in his voice. We won. The judge denied their motion to dismiss. I actually pumped my fist in the air, getting strange looks from my coworkers. What did she say? I'm reading the decision now. Hang on. I heard papers rustling. Okay, here's the key part. The court finds that the easements at issue are recorded property rights that exist independently of the HOA covenants and regulations. The plaintiffs have stated a valid claim for declaratory relief. The requirement for internal HOA remedies does not apply to disputes over property rights that predate and exist separately from HOA membership. Motion to dismiss is denied. The case will proceed to discovery. That's huge, I said. It gets better, Marcus continued. She also wrote, the court notes with concern the allegations regarding the boot lock incident and other alleged harassment. Should the plaintiff wish to pursue injunctive relief to prevent further interference pending resolution of this matter, the court would be receptive to such a motion. What does that mean? It means the judge is practically inviting us to ask for a temporary order telling the HOA to back off while the case is pending. I'm going to file that motion this afternoon. And he did. Within a week, we were back in court for another hearing, this time on our motion for a preliminary injunction. The standard for an injunction required us to show that we were likely to succeed on the merits, that we would suffer irreparable harm without the injunction, and that the balance of harms favored our side. Judge Hensley granted the injunction. Her order stated that pending final resolution of the case, The HOA was prohibited from enforcing its snow machine ban against any plaintiff with a valid trail easement, from issuing further fines related to easement use, and from taking any physical action to prevent easement access. The order also required the HOA to withdraw all existing fines related to trail use. I got the call from Marcus while I was at the grocery store. I stood in the cereal aisle reading the order he had emailed to my phone, feeling a wave of relief and vindication. But the fight was not over. Discovery began, which meant both sides could request documents and take depositions. Marcus requested all HOA board meeting minutes, emails between board members regarding the snow machine ban, and documentation of any complaints the board had received about trail use. What we discovered during discovery was illuminating and infuriating. First, the HOA board had received exactly 3 complaints about snow machine noise over a 2-year period. Just 3. And all 3 came from the same person, Karen Abbott's best friend, Susan Walters, who lived next door to Karen. Second, the board had discussed the easement issue in a closed executive session back in December, before issuing their ban. The meeting minutes showed that Craig Foster had actually warned the other board members that they might not have authority over the easements. Karen had dismissed his concerns, saying they could deal with legal issues if and when they arise. Third, and most damning, we found emails between Karen and Linda Martinez discussing how the ban was really about cleaning up the development and getting rid of the redneck element. Those exact phrases appeared in an email Karen had sent in January. Marcus was ecstatic when he showed me those emails. This is discrimination based on her perception of a lifestyle she disapproves of. This goes way beyond a property dispute. We can argue that the entire ban was motivated by personal bias and abuse of power. The HOA took depositions of all 6 plaintiffs. I spent 4 hours in a conference room being questioned by Sandra Peterson about my snow machine use, my understanding of my easement rights, and every interaction I had had with the HOA. She tried to make it seem like I was a reckless rider who did not care about my neighbors, but I calmly explained that I followed all trail rules, stayed on designated paths, and only rode during reasonable hours. Marcus took depositions of all 3 HOA board members. Karen's deposition was apparently contentious. Marcus told me she had been evasive and defensive, particularly when confronted with her own emails about the redneck element. By late May, both sides had completed discovery, and the case was set for trial in July. But before we got to trial, something unexpected happened. At the June HOA meeting, which I attended out of morbid curiosity, a group of homeowners staged what amounted to a revolt. Led by Patricia, my cookie-bearing neighbor, about 30 homeowners showed up with a petition calling for a special election to recall the entire HOA board. The petition cited abuse of authority, wasteful spending of HOA funds on the lawsuit, selective enforcement of rules, and failure to represent the interests of all homeowners. Under Alaska law and the HOA bylaws, a petition signed by 20% of homeowners could trigger a recall election. Patricia had collected signatures from 53 homeowners, well over the 40 needed for our 200-home development. Karen tried to argue that the petition was invalid for various technical reasons, but Patricia had done her homework. The petition met every requirement in the bylaws. A recall election was scheduled for June 30th. The campaign was vicious. Karen and her supporters sent out mailers claiming that the recall would lead to chaos and that the plaintiffs in the lawsuit were trying to take over the HOA. Our side sent out mailers highlighting the wasted legal fees, the illegal boot lock incident, and the discriminatory emails about redneck elements. On June 30th, 112 homeowners voted, which was the highest turnout in the development's history. The results were decisive: 91 votes to recall, 21 votes to keep the existing board. Karen Abbott, Linda Martinez, and Craig Foster were removed from the HOA board effective immediately. A temporary board was appointed consisting of Patricia and 2 other homeowners until a proper election could be held in August. One of the temporary board's first actions was to review the pending lawsuit. At their first meeting, held just 3 days after the recall, they voted unanimously to settle. Marcus received a call from Sandra Peterson proposing settlement terms. The HOA would officially acknowledge our easement rights, withdraw all fines that had been issued, pay our attorney fees in full, and issue a written apology. In exchange, we would dismiss the lawsuit and agree not to pursue further claims. We all met at Robert's house again to discuss the offer. Jennifer ran the numbers and pointed out that we had each already spent $4,000, and the HOA was offering to reimburse the full $24,000 plus an additional $8,000 for Marcus's time, since the initial retainer. We would each get back our $4,000 plus about $1,300 extra. More importantly, we would have our rights firmly established and no longer face harassment. We agreed to the settlement. The papers were signed on July 15, 2026. The settlement agreement included specific language stating that the trail easements were valid property rights, that easement holders had unlimited access to the trails for recreational purposes, including snow machines, and that the HOA had no authority to regulate easement use. The written apology from the new temporary board was surprisingly sincere. It acknowledged that the previous board had overstepped its authority, acted in bad faith, and caused unnecessary conflict within the community. It apologized specifically to the 6 of us for the harassment and stress we had endured, but the story did not quite end there. In August, I got a call from Officer Martinez, the police officer who had responded to the boot lock incident. He told me that after reviewing all the documentation and consulting with the district attorney, they had decided to file criminal charges against Karen Abbott for unlawful interference with property and criminal mischief related to the boot lock incident. I was surprised. "I never decided to press charges," I said. "You don't have to," Officer Martinez explained. "Once we were aware of a crime, we can investigate and file charges independently. The DA felt that what Mrs. Abbott did was serious enough to warrant prosecution. She used her position to authorize what amounts to vandalism of your property. That's a crime." The criminal case moved slowly through the system. Karen hired a criminal defense attorney and fought the charges. I had to testify at a preliminary hearing in September, explaining what had happened and providing documentation of the HOA dispute. The judge found probable cause to proceed to trial. Karen's attorney tried to negotiate a plea deal, but the prosecutor insisted on at least a conviction on the books because of the abuse of authority aspect. In November 2026, Karen finally accepted a plea agreement. She pleaded guilty to misdemeanor criminal mischief. Her sentence included 6 months probation, community service, and restitution of $500 to cover my attorney fees for dealing with the boot lock incident. The judge also issued a stern lecture about the limits of HOA authority and the seriousness of taking the law into one's own hands. I attended the sentencing hearing. Karen looked diminished somehow, no longer the imperious HOA president, but just a middle-aged woman who had made bad decisions and was facing consequences. She did not make eye contact with me. The new HOA board, elected in August, was a completely different group. Patricia became president, and she was focused on actual community improvement rather than rule enforcement. One of her first initiatives was to create a trail maintenance committee to keep the easement paths in good condition for everyone who used them. I volunteered for the committee. We spent several weekends that fall clearing brush, marking trails clearly, and even building a small bridge over a creek crossing that had always been a bit dodgy. The development felt different after everything that had happened. There was less tension, fewer petty disputes. People seemed to realize that the HOA should serve the community, not control it. I rode my snow machine regularly that winter, the winter of 2026-2027. Every time I fired it up and headed out to the trails, I felt a sense of satisfaction. Not just because I had won, but because I had stood up for what was right, and because the principle of property rights had been upheld. Derek, my neighbor, finally joined me on the trails that winter. He had bought a new snow machine, a ski-doo, and we spent several Saturdays exploring the trail system together. Other easement holders did the same. The trails became popular again, used the way they were always meant to be used. One Saturday in January 2027, almost exactly a year after receiving that first certified letter, I was out on the trails when I came across a family I did not recognize. They had 2 snow machines and a couple of kids bundled up in winter gear riding as passengers. I stopped to say hello. The father introduced himself as Mike. They had just moved into the development, buying one of the homes with trail easement rights. "We heard there was some drama about the trails last year," he said, "but the realtor said everything got settled and we're good to go." "Yeah," I said, smiling behind my helmet visor. "Everything got settled. Welcome to the neighborhood. The trails are yours to enjoy." We chatted for a few more minutes, and I gave him some tips on the best routes and which sections to avoid when the kids were along. Then we went our separate ways, the sound of snow machine engines echoing through the Alaska wilderness. That sound, which Karen Abbott had tried so hard to silence, was now a reminder of something important. Property rights matter. Standing up to overreach matters. And sometimes, you have to fight for what is legally and rightfully yours, even when it would be easier to just back down. As I rode back toward home that day, the winter sun low on the horizon casting long shadows across the snow, I thought about everything that had happened over the past year. The confrontations, the legal battles, the stress and expense, the community division and eventual healing. It had been exhausting and frustrating, but it had also been necessary. The trails wound through the spruce forest, the same paths I had ridden dozens of times before. But somehow they felt different now, better. They were not just trails anymore. They represented something larger, the principle that you cannot simply take away someone's legal rights because you find them inconvenient or distasteful. Karen Abbott had learned that lesson the hard way. The old HOA board had learned it, and the community as a whole had learned that HOA authority has limits, and those limits matter. I arrived back at my house as the sun was setting, painting the sky in shades of orange and pink. I parked my snow machine in the driveway, right out in the open where it had always been. No boot locks, no threatening letters, no harassment. Just my property on my land, secured by my legal rights. Patricia waved at me from across the street where she was shoveling her driveway. I waved back. The new HOA under her leadership had just sent out a newsletter highlighting upcoming community events, including a winter festival in February that would feature snow machine trail rides as one of the activities. The change in tone and priorities was remarkable. Inside my house, I made coffee and sat down at my kitchen table with my laptop. I had started documenting the entire experience, writing down everything that had happened from that first letter in January 2026 through the final resolution. Part of me thought about turning it into an article or blog post, something that might help other homeowners facing similar HOA overreach. The legal precedent from our case had actually been cited in another Alaska case already. Marcus had sent me a link to a decision from Fairbanks, where homeowners were fighting an HOA ban on RV parking, and the judge had referenced Judge Hensley's ruling in our case, particularly the language about recorded property rights existing independently of HOA authority. It felt good to know that our fight had helped establish clear legal principles that would protect other people's rights too. Over the following months, life in Timber Ridge development continued to improve. The new HOA board focused on real issues like road maintenance, snow removal, and community events, rather than trying to micromanage everyone's lifestyle choices. Violation notices became rare, issued only for legitimate problems like someone leaving garbage bins out for days or a genuinely dangerous situation. The trails became a source of community pride rather than conflict. During the Winter Festival in February 2027, over 100 people participated in trail activities. Families rode snow machines, some people snowshoed the paths, and a few hardy souls even cross-country skied portions of the trail system. The event was covered by a local Anchorage news station, highlighting the development's recreational amenities. I was interviewed for that news segment. The reporter asked about the previous year's controversy, and I kept my answer diplomatic. There was a misunderstanding about property rights that got resolved through the legal system, I said. Now we're all focused on enjoying these amazing trails and building a stronger community. What I did not say on camera was how close things had come to a much worse outcome. If we had not had the resources to hire Marcus, if the law had not been clearly on our side, if Judge Hensley had not been a careful and fair jurist, things could have gone very differently. Karen and the old board could have steamrolled over our rights, and we would have been helpless to stop them. That thought bothered me enough that I did end up writing an article about the experience. I published it on a property rights blog, detailing the dispute and the lessons learned. The article got shared widely in HOA reform circles, and I received emails from people all over the country dealing with similar issues. One email came from a veteran in Colorado who was fighting his HOA over displaying an American flag, which the HOA claimed violated their aesthetic guidelines. Federal law actually protects flag displays, but his HOA was trying to fine him anyway. I was able to connect him with information about the legal protections and suggested he contact an attorney. He later wrote back to tell me the HOA backed down once he sent them a letter explaining the law. Another email came from a woman in Florida whose HOA was trying to ban solar panels on roofs. She used some of the legal arguments from our case to fight back, pointing out that Florida has specific laws protecting solar panel installation. She won her battle too. These small victories mattered. Every time someone successfully stood up to HOA overreach, it established a clearer boundary and made it a little harder for the next power-hungry board to abuse their authority. By the spring of 2027, the trails had dried out enough for different activities. Some people started mountain biking the paths. Others used them for hiking. The easements did not specify snow machines only. They granted general recreational access, so all these uses were legitimate. The Trail Maintenance Committee expanded its scope, working to make the paths usable year-round. We installed better drainage in a few muddy sections, cleared sight lines at intersections, and even put up some directional signs to help new users navigate the system. I found myself becoming more involved in community leadership, something I never expected. Patricia asked me to join the Architectural Review Committee, and I agreed on the condition that we focus on genuine architectural concerns, rather than nitpicking people over minor color variations or mailbox styles. The committee became much more reasonable, approving projects quickly when they met basic standards, and working cooperatively with homeowners when modifications were needed. The development attracted new buyers specifically because of the trail access and the reputation for reasonable HOA governance. Property values actually increased, contradicting Frank's dire predictions about my lawsuit destroying the neighborhood. Turns out people prefer living in communities where property rights are respected, and the HOA is not constantly harassing residents. Karen Abbott moved out of the development in the summer of 2027. I heard through the neighborhood grapevine that she and her husband sold their house and relocated to a condo in Anchorage with no HOA. The irony was not lost on anyone. Linda Martinez and Craig Foster stayed in the development but kept low profiles, no longer involved in HOA governance. The criminal mischief conviction on Karen's record had consequences beyond just the probation and community service. She had worked as a real estate agent, and the conviction caused professional problems for her. While I did not take any pleasure in her struggles, I could not help but feel that there were real consequences to abusing authority, as there should be. By the fall of 2027, nearly 2 years after the initial conflict began, Timber Ridge development had completely transformed. The HOA functioned the way it was supposed to, maintaining common areas and handling administrative tasks without trying to control every aspect of residents' lives. The community was friendlier, with regular social events that brought people together rather than dividing them. The trails remained the centerpiece of the development's appeal. On any given weekend, you could see people of all ages enjoying the easement paths in various ways. Young families hiking with kids, teenagers mountain biking, adults on snow machines in winter or motorcycles in summer, elderly couples taking leisurely walks. The trails belonged to everyone who had easement rights, and they were used and cherished. I continued to ride my snow machine regularly each winter. The Polaris was getting older, showing some wear after years of use, but it still ran strong. I took good care of it, knowing it represented more than just a recreational vehicle. It symbolized the principle I had fought for, the right to use and enjoy my own property without unjust interference. Derek and I became good friends through the whole experience, bonded by our shared love of trail riding and our mutual frustration with the old HOA board. We started an informal snow machine club in the development, organizing group rides and trail cleanups. About 15 easement holders became regular participants. One of the group rides in January 2028 was particularly memorable. We had about 12 snow machines, and we spent the entire day exploring the full trail system, stopping for lunch at a scenic overlook where you could see all the way to Denali on a clear day. The weather was perfect, temperatures in the mid-20s and bright sunshine. As we sat on our parked snow machines eating sandwiches and drinking coffee from thermoses, someone brought up the old HOA conflict. Robert, one of the other original plaintiffs, raised his coffee cup in a toast. "To Brandon," he said, "for having the guts to ride through when they tried to stop him." Everyone raised their cups and echoed the toast. I felt a little embarrassed but also proud. "To all of us," I corrected. "We stood up together. That's what made the difference." And that was true. If I had been the only one fighting, The HOA might have been able to wear me down or isolate me as a troublemaker. But with 6 property owners united, backed by solid legal grounds and good legal counsel, we had been able to successfully defend our rights. The experience taught me valuable lessons about community, about law, and about the importance of standing up for principles, even when it is difficult and expensive. It also taught me about the dangers of unchecked authority, even at the relatively minor level of a homeowners association. HOAs serve important functions, maintaining common areas and protecting property values through reasonable standards. But when they overstep, when board members let power go to their heads and start trying to control their neighbors' lives beyond legitimate HOA concerns, they can cause tremendous damage. The key is accountability. In our case, accountability came through the legal system when the court ruled in our favor, through the criminal justice system when Karen faced charges for her illegal actions, and through the democratic process when homeowners recalled the overreaching board. All 3 forms of accountability were necessary. The legal ruling established the principle. The criminal charges provided personal consequences for abuse of authority, and the recall election gave the community a chance to choose better leadership. As I sat on that overlook with my friends and neighbors, looking out at the magnificent Alaska landscape, I felt grateful for all of it. Grateful for the trails themselves, grateful for the legal system that had protected my rights, grateful for the community that had ultimately come together, and grateful for the opportunity to make a difference. The sun was starting to descend toward the horizon, that brief winter afternoon already drawing to a close. We packed up our lunch gear and fired up our snow machines for the ride back. The engines roared to life, that distinctive sound carrying across the snow-covered wilderness. As we rode back through the forest trails, I thought about that first morning when I had decided to ride through despite the HOA ban. It had seemed like a simple act of defiance at the time, standing up for what I knew was right. I had not anticipated the legal battle, the community division, the stress and expense and time involved in seeing the fight through to its conclusion. But I would do it all again in a heartbeat. Some things are worth fighting for. Property rights are worth fighting for. The principle that no one, not even a duly elected HOA board, can simply take away your legal rights on a whim, that is worth fighting for too. We emerged from the forest trail back into the development as the sun was setting. The houses looked warm and inviting with lights glowing in windows against the growing darkness. Smoke rose from chimneys where wood stoves and fireplaces were burning. It looked like a perfect community, peaceful and prosperous. And it was, now that the conflict had been resolved and reasonable leadership had been restored. The development had survived its crisis and come out stronger for it. I pulled into my driveway and shut off the Polaris, the sudden silence feeling profound after hours of engine noise. I sat there for a moment, still wearing my helmet, watching the last light fade from the sky. My phone buzzed with a text from Derek. "Great ride today. Same time next weekend," I smiled and texted back. "Absolutely." Because that is what it was all about in the end. The freedom to enjoy my property, to pursue my recreation, to live my life without unjust interference. Simple freedoms that should never have been threatened, but that I had been forced to fight to preserve. The fight was over now, won decisively on every front. The trails were secure, the legal principles established, the HOA reformed. Life in Timber Ridge development had returned to normal, or rather, had reached a new and better normal where property rights were respected and HOA authority was appropriately limited. I climbed off my snow machine and headed inside to the warmth of my house, already looking forward to the next weekend's ride. The trails would be waiting as they always had been, as they always would be. They were mine to use, legally and rightfully, and no one could take that away. That knowledge, earned through months of struggle and legal battle, was immensely satisfying. I had stood up for my rights when it would have been easier to back down. I had faced down an overreaching HOA and won. And in doing so, I had helped establish principles that would protect not just my own rights, but the rights of others in similar situations. As I settled in for the evening, I realized that the entire experience, difficult as it had been, was ultimately a positive one. It had strengthened my resolve, deepened my understanding of property law, connected me with good neighbors who became real friends, and improved my community by removing abusive leadership and establishing better governance. The trails through the Alaska wilderness had been the catalyst for all of it. Those paths winding through spruce forest and across frozen meadows had become symbols of freedom and property rights, worth every hour spent in legal battles and every dollar spent on attorney fees. And tomorrow and next weekend, and all the weekends after that, those trails would still be there, waiting for me and everyone else with easement rights to enjoy them. That was victory, complete and permanent. The HOA had tried to take away our legal rights and had failed utterly. The law had prevailed, justice had been served, and life had moved on better than before. I looked out my window at my snow machine sitting in the driveway, illuminated by the porch light. No boot lock, no threatening letters, no harassment. Just my property, legally used and enjoyed, exactly as it should be. That simple sight represented everything we had fought for and won, and it felt absolutely perfect.